Thank you.
I'll do it. $4. I'm good.
All right, good evening. Welcome to the December 3rd Plastow Planning Board meeting. Charlene, could you read the roll, please? Call the roll.
Richard Anthony,
Here.
Karen Robinson. Here. Dan Kane.
Here.
Rich Leclerc.
Here.
Nolan Pelletier.
Here.
Bill Coy.
Here.
Liz Costa.
Here.
And Shay Raymaker.
Here.
Excellent. I think there should be some draft minutes in here. I think I
We
just saw
approved
them.
those at the last.
Right,
All right.
correct.
Good
No,
match.
but we got to approve,
The minutes from the last meeting.
yeah, which was only about a 2-minute meeting.
Exactly.
All approved.
So those got to be approved.
Okay.
That's it.
I know I saw it.
Yeah, I'll make a motion to approve the minutes from November 25th, 2025.
A second.
All right, any discussion? All in favor? Aye. Opposed, abstain? 500. All right. Well, we have a bunch of public hearings that we need to go through. Before I open the public hearings, and I think there was a request that we probably go through, switch them up a little bit. I know that's listed as Article 2, 3, 4, and 5. Dan, you had a request that you felt that we should do fees first,
I
or
thought
do you
we
not?
should just knock off fees first, but
Yeah.
All right. Which one's that? All right. Before I open a public hearing, is there anything that you want to discuss?
Yeah, the only thing I wanted to bring up, I made a request, sent an email to Shay earlier today. I should have done it sooner. The only thing I wanted to see is back from legal where they said no changes were needed, that we were good to go with the way they're written. It's just, I think I should be able to see something like that. And that's all.
Okay.
there's no correspondence that says that.
There was no email, you didn't send an email to
Oh,
them?
I did. We went through each ordinance, legal made comments, and I implemented their comments.
Right, but I was hoping to see those comments just to, look, it just,
Certainly can. I mean,
Well, wait. Let me understand the question. Is the question that we're looking to have something affirmative from legal saying that the proposed warrants are in good order?
yeah, that's all I want to say.
So I did call them prior to this meeting. I did speak to Flora, and indicated that is there with respect to the back and forth and the editing, are we in good order? All right. And then the first round of edits, she said that she reviewed them, she proposed, made comments, and our work methodology was to incorporate those comments. All right. So I asked her explicitly that if those comments were implemented, we're good to go. And the answer is yes.
But she didn't send, there's no email that says these are good to go. That's all I wanted to see, just
Right.
good to go.
We have a conversation of legal that I had at 5 o'clock, all right, to, sort of memorialize that understanding. Right. And so, so if there is anything, let's say that during the public hearing, while it's open and we, let's say, substantively amend something, then something like that, we'd want to go back to legal since it represents something that's outside of the scope of that work
Right.
session.
My thing is, I just want to make sure
Right.
that they blessed it, okay, and I just wanted to see something like that in writing. That's all I'm asking
Well,
for. I don't think that's a whole lot.
See it. We all know.
Right, but I guess what
and I
I'm
take your-
saying
I
it's
take your word
it's the
for it, and I
it's the
believe
day
it.
of the public
I
hearing.
understand it. I understand
Seems
all
that
this. So it's just something I'd like to see. And obviously, as someone that when bills come in and you got to pay them, you like to make sure something was done. That's all. Those are things that I should be able to see.
I guess I don't follow that analogy, but I mean, like I said, if there was a request, it seems kind of extraordinary at the day of the public hearing to ask for that.
I just have a question regarding that. I mean, my understanding was you said you emailed Shay, correct? I've been told previously, even in another committee that I sit on, that everything has to go through the chair. So it just doesn't make sense to me that you were contacting Shay if that's the way it's going. Because I actually, on this other committee, I wasn't getting the information that we had asked for. And when I asked the department heads, I was pretty much scolded by the chair and the town manager saying that there's a protocol in place and everything goes through the chair. I've also been told, when I've asked for other information concerning boards and the lawyers, I've been told by the selectmen that it is privileged information. And because I've done RTKs and I've come back that it's like a privileged information. So I would love clarification from the selectmen where the policy is and what is available to the public with respect to communication between boards and the lawyers. So if you would like to clarify that, I would really appreciate it.
We can obviously sit down and discuss it with all the different chairs and all that and go from there.
We're
I'm
having,
just saying,
we're having a discussion right now, Mr.
I mean, I don't even need anything sent to me. Somebody could just show me the email right now and I'm good to go. That's all.
But as I said, Bill, we don't have like an email
Right.
that says this went down
Right.
article by article by article,
Right.
you know? And she made comments, had some questions. They were relatively minor for the most
No, I
part.
know you said that and I believe you.
I just put them in. I did the same thing last year with Attorney Cleary.
Right.
The difference this year is we intentionally did not push this through the planning department because this is privileged communication between a client, which is the planning board, and their attorneys.
Right.
Once it goes out into the world, it's no longer privileged. You know, and it's not privileged to me, even though I was I was the one, you know, initiated by the chair to have that conversation. It's privileged amongst just the planning board.
Right.
So, you know, there's no intent to hide here.
Oh,
I can give you all that. I
That's all
don't
I
have a
want.
problem.
No, that's
But
all
I don't
want.
have it right this second.
That's all I want, and I'll tell you. And I have no problem with any of these. I don't. I've said that all along. I have no problem. What I'll do is I'll just, in good faith, I'll have no problem approving these because I agree with them. But just please show me those and we're good to go. That's all I'm asking.
Be happy to.
That's all I'm
Let me,
asking.
with respect to showing emails, that's fine. All right, but if there's anything that, I mean, if I guess I don't want it to be an ad hoc process. I mean, if this board wants to see that legal correspondence, okay, and see how the sausage is made, you have the back and forth, then that's fine.
Well,
Then I would entertain a motion from the board to do that, and then we would have to schedule, I think, some time where we go into non-public to discuss privileged information. Right, but if we're saying that there needs to be something that's, going to be like, here, I'm going to show you some emails on the fly. I don't want to see emails with privileged information, flying around cyberspace and things
No,
like that.
when something's privileged, it should be done in non-public.
Right.
That's what we do. We do it in non-public and that's how it should be. I don't disagree.
So, I mean,
with that at all.
I can envision that if that's the case, and, again, it's sort of the 12th hour to say that we have a public hearing, and then all of a sudden somebody wants to review,
No.
all the back and forth.
And what I just said is I have no problems with any of these. So I will vote yes on them, and then Dan said he'll show them, and we're good. That's all.
All right.
That's
I
that
think-
simple.
Well,
Just one thing we might, just because we do have rules of procedure.
yes.
Okay. So generally the rules of procedure say that when we have conversations with outside counsel, we need to do a writing of a summary of those conversations, So in essence, while we didn't do a writing, going through them all last meeting was effectively, which would have been in a writing, I mean, and we went through what generally the comments were. So to me, that's fine. And I personally don't have a problem sharing that communication in a non-public. I think that to me is communication with counsel, you know?
Right.
Agreed.
So if we're going to do that, then, we should probably make a motion and say we're going to do that, not just someone coming over and, hey, I got an email for you to look over my shoulder.
What we'll do is maybe go non-public at our next meeting. Let's get through what we got to do tonight.
All
We'll
right.
just do it next meeting.
All right. Well, some point in this meeting, then someone make the motion.
Yeah.
And that way people can, prepare, put together those emails that need to be
Yeah,
reviewed.
we can just say now we're going to non-public
All
for
right.
the next one, and that's fine. Because we got a lot to do tonight, so
Right.
let's get on with it.
All right.
If you'll pardon some of my colorful language.
I wouldn't expect anything less.
No F-bombs, though, in the emails. I'll just,
Well, now I'm disappointed.
yeah, well. Sometimes it's hard to police myself, but I do try.
All right. With respect to the public here, any other input, comments procedurally with respect to that?
Well, we want to open it for fees, right?
Right. And which one is this then that we're looking at? I don't see it on here. Oh, planning board fee scheduled public hearing. How about that? All right. So at 6:43, I'm going to open the planning board fee scheduled public hearing. All right. All right. So you should see in your packet, there should be a planning board feed schedule. Dan, if you want to give us,
Where's that we going to?
it's the last one. It doesn't have a number associated with it.
Well, there's 2 pages here.
Yeah.
One which just kind of goes from what the existing
Last one.
fee is to what the proposed is. And I will tell you where I got these, as I mentioned probably previously. I used Fremont as an example. I used Seabrook as an example. I used Bow as an example and Wyndham as an example. And my motivation in terms of proposing these was essentially I thought we were leaving a lot of money on the table. And, a fair amount of our staff work is done for the benefit of applicants, and we should be getting reimbursed for that. In fact, our budget, it's predicate upon this fee, these fees. So there's a lot of things that we do. There were a lot of things that we do that we weren't getting paid for. Managing the escrows, managing the bonds. If our staff does work, what should they be getting paid for that work? And you can see down below, I mean, a big thing that results in a bigger capture is how we calculate site plan fees in terms of how much of impacted area. Every time we look at a site plan, the more the impacted area, the harder it is to look at, because you're looking at more activity, you're looking at more of what's going on. It's requiring more staff work to gather data. That should be reflected in how we calculate our fees.
And that's where you have impact areas that
Yes,
you're referring
that's
to.
correct.
All right.
That's right from the town of Seabrook, just so you know that. No.
Yeah.
There's not $1 in here that didn't come from another town. We've got our staff doing administrative work, monitoring work. That should be getting reflected in some form of compensation. These are for the benefit of the applicants.
And all the 4 towns that you mentioned, this is what they charge pretty much Is it pretty consistent what each town charges?
It's not, it's all over the place.
That's why I
You know?
figured that was gonna be the
It's
case.
all-
Exactly.
It's all over the place.
different.
And I didn't take the highest fee
Okay.
from everyone. I kind of looked at, okay, what's more reasonable,
Okay.
you know? You'll see smaller towns charge a lot higher fees, you know? Given their limited resources, that's not larger towns. You go to Manchester and Nashua or anything, those fees aren't as substantial, although Nashua is, you know? So I took big towns, and then I'll tell you, when I look at things relative to Plastow, I always take the 10 towns that go down in population. I always take the 10 towns that go above.
Yep.
So Epping, those kind of places, I start looking, okay, what are they doing?
Yep.
You know, Atkinson I look at. I always look at Newton. I always look at Hampstead. So that's what I did.
Okay.
You know?
Maybe a little, with respect to the escrow, I mean, that's where we're seeing the largest, I mean, granted, that's not a fee, that's just something that's,
No, and it just gives more coverage. But to me, there's a relation to the fee to the escrow. If you're charging more fees, your escrow is going to, you know, you need more escrow to cover at least the initial batch. I asked for a bunch of escrow data. I didn't get it. I was really looking to kind of validate this. And to me, if we do get the data, or now that we're having this, we'll see the data, you know, we may next year decide that, hey, the escrow can change, can come down, because we're seeing how much goes back. So if, for example, we're charging a 5,000 escrow, but on 80% of the site plans, we're sending back $2,500, then we probably don't need to charge a $5,000 escrow.
Yeah, so let's just look at it every year.
Yeah, I think
all right.
that makes sense.
Now, in terms of just procedurally what we're doing here, I mean, this isn't going to, for the voters to approve or anything. This is something that we close the hearing, we can vote on.
Yeah, it's our responsibility.
Is this something that do we have to have legal review or?
I not required
just-
to. Yeah.
I mean, we're just setting fees or updating fees.
I tend to be more on the cautious side, just.
Yeah, no, you know, we're entitled to set our fees. We're entitled to set.
Exactly.
And if you recall the budget presentation, it relates our fees to what we charge, what we cover. So, you know, what the statute says is that we're entitled to recover the cost of processing site plans
Correct.
and the like.
Correct.
And we just about do it here in the way this is set up.
Yeah, we're not making any money here.
No,
We're not making any money here.
Now, realistically,
No.
if we adopt this fee schedule, when does it take effect? Is that
immediately.
immediately?
Well, immediately when we publish it, we need to publish it.
Oh,
Okay.
didn't do that.
I mean, we can set the date we want it to take effect. You know,
Would it make sense? I'm just trying to think of when you would do it. Would you want to do it calendar year?
I would.
Or would you want to do it? Yeah, because it doesn't have to go to warrant or anything like that. So calendar year makes, that way there it's consistent.
In the motion, if I was making the motion, would be to make these effective January 1st.
Right.
We can get them published. They're out there.
And that makes sense too, because the budget starts on the calendar
Yeah.
year too. So that way there was all ties into that.
Yep. Yep.
All right.
And it doesn't affect anyone who's coming in the next meeting or their,
Yeah, which is quick for them.
yeah.
Right.
Yeah.
All right. Anything else from the board on the subject of fees? All right, so we'd want to close the hearing at this point, right?
Yes.
So at 6:50, I'll close the public hearing with respect to planning board fee schedule. All right. Public hearing for amendments to the planning board fee. I move to approve the amended planning board fees schedule to be effective January 1st, 2026.
I'll second it.
Any discussion?
The only thing I might add to that is that we'll review it every year, the fees.
No.
Just because what Dan said, we'll look at it, we may notice we might have to make adjustments. Like say maybe we'll review it in November of every year or something like that.
All right.
Just to review it every year.
Do we even have to do that? If it's within our powers and our peer review, I don't even think we can adjust that well.
Right,
Yeah, I think we can adjust them anytime we want, really.
right, exactly.
Well, so if it's the intent of the board to, to revisit this, then I don't need.
Yep.
That's fine.
We could just revisit it.
I mean,
Yeah.
everything goes up every year.
Right,
Well, remember, these things weren't adjusted for 7 years.
right.
Amazing.
Yeah.
That is
I
amazing.
can't believe that.
It's a good thing prices
So
have stayed
some of the-
constant in those 7 years.
Some of the
Let's not even go there.
difference in the change, obviously, is a reflection of, you're bringing the Trail of Tears along with you with respect to every year. So,
All right.
Yeah.
Any other discussion?
No.
All right. All in favor?
I
Opposed? Abstain? All right. So 500. All right. So do you want to just proceed from the top down at this point?
Sure.
Start with number one.
You bring your throat lozenges with you?
C-26 one, right? You don't have.
Before we, open up the next public hearing, I specifically asked legal today whether or not we have to read, the warrant article into the record. I mean, as and the answer is emphatically no. So, and when looking out on, whatever RSAs that we're looking at, there's nothing that says that we have to read the proposed amendment or anything. I mean, as long as we're discussing it and the proposed changes are available, I don't see anything that says that we have to read.
We have to read just what the changes are? I just want to make sure we're covered.
Yeah, we don't need to read it. Okay. It's just as long as,
To discuss each one.
as we're discussing the opening the hearing and discussing the warrant.
These are out in the sphere already.
Right.
Yeah.
Okay. And to the extent we don't make any changes, any substantive changes,
Yeah.
then
Yeah, because the days where we were reading, doing marathon reading sessions, it's like,
trust me,
I
I've
was
been
like,
through
where
it.
is,
Dan will tell you one night, the one I had to read.
where is it in the RSA? It says we're supposed to do that. And our, legal said, no, we don't.
Okay.
So
Mr.
I
Chair,
propose that when we open the public hearing,
it wouldn't really be a point of information. I wouldn't know if it would be possible for to put the link up where this information is on the screen, just so if people are watching at home, if they do want to review with us, they have that capability for quickly finding it. I don't know if that would be a possibility.
yeah, good idea.
Yeah, very good.
That'll be like reading it.
well, yeah, it's just, I think I just propose that when we open the hearing, we have the hearing, we will, give an overview, discuss what the substantive changes are, and the intent.
Yeah, these aren't like earth-shattering ones this year.
No, but, it's, and then there's some back and forth on it. And then we'll close the hearing if there's nothing.
We're going to take each one as open a hearing.
Yes,
Look
so-
at it, close it. Okay.
Right.
Do we have to do it open and close each one, or can we just go right through? I'm just trying to save time.
Yeah. Please.
I would suspect we can open the hearing and go through each one.
That's what I'm
Don't
thinking.
you think?
That's what I'm thinking.
Once you vote on it, isn't that hearing then closed for each individual one?
So I'm thinking that if you're going to vote, I think the hearing is then, you're closed when you're voting. So,
I'm good either way.
all right. So I'm going to open.
Well, if the vote was the same on every one, you wouldn't have that problem.
All right, I'm going to open the, these things aren't listed as. All right.
Do you want to
I'm
run?
going to open the public hearing for proposed Article Z26-1 at 6:50.
Yeah, because you can just open it up. That way someone can see it on the screen, right?
All right, once we,
It's your turn to be the guinea pig, Andy. At least they gave you a mouse.
all right, so while we're waiting for that to come up, we'll just basically, all right, so proposed Plastow zoning amendment Z26-1. Are you in favor of the adoption of amendment number 1 as proposed by the Plastow Planning Board to the Plastow zoning ordinance to amend Article 12 conditional use permits to read as follows? All right, so, I mean, this one is standards applicable to all conditional use permits, a specific authorization for conditional use permitted within the ordinances. So 22085, hearing and decision. Following a public hearing on the proposed use, the planning board shall issue a conditional use permit if it finds, based on the information testimony submitted with respect to the application, that A, the use is specifically authorized by the ordinance as a conditional use. So I guess my question right off is what's new about this? Is we just striking out where it's indicated, Mr. Kane, Article 5,
Yeah, I
to say
just-
the ordinance?
Because the ordinance establishes the use, not necessarily Article 5. Article 5 just places it in a table.
Okay. So is that the only substantive change here that we're talking about?
Only change.
All right. All right. Any questions from anyone on the board? The public? None?
Somebody there?
Excellent.
Don't rush the mic.
So with respect to the public hearing for Z26-1, I'm going to close the public hearing at 7:52. All right.
Maybe 6:52?
What's that? 6:52.
Yeah.
Yes, all right.
I was gonna say,
I-
what the hour ago?
I'm working with some new transitional lenses here, okay?
Time flies.
Well, they're
All
not transitioning too well.
Exactly. Thank you. All right. So I move to post the proposed zoning amendment Z26-1 to the warrant as being recommended by the planning board.
I'll
Or the
second.
second. Discussion? All in favor? Aye. Opposed? Abstain? 500. All right. I'm going to open the public hearing for proposed Article Z26-2 at 6:54. All right. I think this is the one where, why don't we just talk substantively about, are you in favor of the adoption of the amendment number 2 as proposed by the Plastow Planning Board to the Plastow zoning ordinance, Article 2, Section 220-2, definitions to add definitions of terms included in the recent enactment of statutes by the New Hampshire legislature, define uses that have been permitted but never defined, i.e. blank, and clarify the terms used in the table of setback and dimensional standards to read as follows. Do we want to enumerate or
Yeah,
just sort
I mean,
of touch upon?
the three basic things here, as we discussed at the last meeting, there's 24 definitions that were permitted uses in the zoning ordinance that never had that were never defined. So all did was go back, define those. The dimensional tables had terms that weren't defined in the ordinance, setback, building coverage, so we just created definitions to match how they were being used in the tables. And then accessory dwelling units were never defined in the definitions in the ordinance. We used the definition from the state. This is actually one of the changes that the council had recommended is I'd actually used the exact statutory definition. And Laura suggested that we don't do that, if you will, that we refer to that within the ordinance itself, but the definition stays as a fairly straightforward definition without quoting from the state RSAs. And that's pretty much the nature of these things. The general rule here, and this comes from the committee, is we looked at if we touched an ordinance in any material way, we fixed for any defined terms, So defined term is a term that's defined in the ordinance. And that typical is what we do is we capitalize the first two letters of that. So we let people know, hey, this is a defined term. You can go find its actual definition within Article 2. So we did that here. We did that in Article 3, and we did that in Article 5 too. So that's kind of, if we were touching these in a material way, we did that.
You want to just enumerate the definitions that, aside, I see that, we have accessory dwelling, but you want to just go down and just sort of,
On every one of them.
well, the ones that are added, maybe, I don't know.
Well, accessory dwelling unit, typically anything in bold is what we may change. Accessory dwelling unit, adaptive reuse, that's part of the statutory requirements. Agriculture just relates to 2134, we didn't have a definition. Approved plan, we didn't have it, we refer to it, but we didn't have a definition of it. Bank, no definition. Bank kiosk, no definition. Building coverage, building footprint, and building area are all related to the dimensional tables in Article 5. Proved upon the definition of business office, just made it a little bit more detailed. Cemetery, didn't have a term. Class 6 road, we didn't have a definition, and there was a change in that provision in Article 3. So I deem that as a statutory kind of change. Commercial equipment, commercial recreation, we refer to the terms, but we never define them. Construction equipment, same thing. We refer to the term, but didn't define it. Duplex, townhouse, we refer to it, didn't define it. The changes to multifamily dwelling couldn't limit those to families under the new statute. So we had to tweak that language. Farm animals, forestry, fraternal services, again, terms that were in the ordinance but weren't defined. Funeral establishment. Grade plane really relates to building height. That's the basis from which you establish the height. High hazard use, we use that term, didn't define it. Hospital, didn't define it. Local legislative body, we used the term, but we didn't define it. Lot area, we used the term, but didn't define it. Medical office building, same thing. Non-conforming lot, non-conforming structure, non-conforming use, these all relate to what is Z26-6. When we go through 3 and 6, we can go back, but these got changed. Outpatient was a term that wasn't defined. Pervious service was a term that wasn't defined. Place of worship. And this was a term that wasn't defined. And this also came up in a matter we had with us last meeting. These can't be limited. They're permitted in all districts. private public recreation, private public schools, private service club, produce stand, public use limited to public safety, publishing, all terms we used, but not defined. Rail services and rail station, terms that weren't defined. Residential care service facilities, term used but not defined. Research and testing labs, again, a term used, not defined. Self-storage warehouse, not defined. Setback areas, setback rear, setback, these are all dimensional definitions. Storage container, storage trailer, story above plane grade. Story and story above plane grade relate to building height, so that's why they're in there. And these are definitions that generally comport to the building code. Urgent care facility was a term that wasn't defined. I'm ignoring things where we just capitalized. Okay? And zoning officer is the definition from last year, matches the code enforcement officer. That's the extent. I mean, there's a lot here, but that's the extent of it.
Any questions from the board? Public? And just to highlight, you said non-conforming structure, that's going to tie into another ordinance that we have, correct?
6, yep, Z26-6. We had no definition. All we had is a definition of a non-conforming lot, non-conforming use. We had no definition. And the non-conforming lot was deemed to be a defective definition. So that's why we changed it.
All right.
The whole motivation here is the same as last year when we looked at this.
Really?
Any way to make these things more specific and more detailed, we should, we should be working to all the time, just because we're asking the rest of our fellow citizens to go through and read these, and when they go look at a use and then go, okay, what's that use defined, and there's no definition, then, ambiguity is the enemy of these ordinances, in my opinion.
Anyone else?
Nope.
All right, then I'll close the public hearing for Z 26-2 at 7:10. I move to post the proposed zoning amendment Z 26-2 to the warrant as being recommended by the planning board.
I'll second it.
Second by Karen. Any discussion? All in favor?
Doing it again.
The serial seconder.
All in favor?
Aye.
Aye.
All right.
Opposed? Abstain? All right.
What to do, Karen, when you second it, bang your cane with a get. When you're gonna second something or make the motion, just bang your cane. Be like a gavel.
There we go.
All right. Z26-3. All right. I'm going to open the public hearing for Z26-3 at 7:10. Proposed Z26-3, proposed Plastow zoning amendment Z26-3. Are you in favor of the adoption of the amendment number 3 as proposed by the Plastow Planning Board to the Plastow zoning ordinance Articles 3, general provisions to read as follows. All right. I think we can use the same methodology that we did for the previous one.
Summary,
just
yeah.
to talk about the proposed changes.
The majority of these changes were moving things from Article 5 to here, because they relate more to the general provisions of the ordinance versus specifics that Article 5 tends to deal with in permitted uses. I think the major change here is the requirement that everyone participate in a conceptual discussion or design review when they come before us.
All right, that's this portion down here where it says the planning board shall require that all applicants for a site plan or subdivision participate in a preliminary conceptual consultation or design review as outlined in Article 3, 235-12A1 or 2 of the town subdivision regulation. That's
The thing here is I think from my limited experience on the planning board, where I've seen people come in for conceptual consultation, it's a benefit to them
It is.
versus coming in, somewhat cold, maybe having, questions relative to their zoning. I mean, we could help, which is our duty. We can help applicants by pointing them in a direction that probably leads to a more successful site plan process. That to me, that's the biggest change in Article 3. Other than moving non-conforming activity to its own ordinance.
where are we seeing that one?
But non-conforming,
That's over here.
226, 7, and 8. Things get moved.
Six, 7, 8.
Is it being moved to Article 16? Is that what we're saying?
Well, it's
That was Article,
Z26-6 here, but it goes to Article 16. Article
Okay.
16 had nothing in it.
Okay.
Okay. Sixty.
So things like care and treatment of animals, this is what went over this last time. Temporary structures and uses, those are terms that just got moved from Article 5 to Article 3. Anything with that looked general in nature, and this isn't unique to Plastow. Virtually every time you look at an Article 3 in any zoning ordinance, it's always referring to general provisions, just like Article 2 is always referring to definitions.
Definitions.
Construction times?
That's the same language we talked about moving from the noise ordinance, just took the same language. We were talking about town holidays versus federal holidays. They're almost identical when I went back and looked. I think there's one difference. And I didn't think it was worth changing it here and then having to change it in the noise ordinance. So I just left the two together. But that was the conversation we had from town holidays to federal. But I only saw one, Bill, so I was
Okay.
like,
Only one.
That's fine.
you know.
Fishy Game gets to see these too.
Like storage of hazardous materials, just, that looks like we're lining out, say, to include no person or business. So no person and/or business shall be engaged in the transport, storage, treatment, disposal of any use of hazardous material. That's a defined term, right?
Yes.
Okay. In any districts within the town, without a permit identifying the name and use of each substance or hazardous material. Of each hazardous material, all right.
Business captures all of those terms that are stricken.
All right, so,
If we were going to make any change to this, I would add regulated substances. So in that second sentence, I would say use of any hazardous material or regulated substance in any district. Regulated substances has got a little bit broader. And, and I think this is contextual. Given the Superfund site nature of some of our parts of the town, I think the town should be more restrictive as to hazardous material, regulated materials than less. We've got the experience to warrant it. It adds a little bit more, tightness to what we have, but that would be a recommendation to insert that phrase.
No, I'd be good with that.
Yep.
I think that makes sense,
Yeah.
just because of the history of the town.
Yeah, I think everything's in context.
You think?
It should have been done 80 years ago.
Yeah.
Exactly.
Unfortunately not.
all right,
but-
so where are we adding it just before hazardous material? We're calling it what?
So you're adding in that second sentence, you'd be saying, where it starts after the comma, or any use of, you'd add the word any hazardous material,
This material.
or you would add the word or regulated substance in any district.
Okay.
Again, I don't think this is a substantial change, but
No,
No.
I wouldn't think so. I wouldn't think
no,
so.
that isn't, no.
All right.
No.
remember, we get to look at everything. It's a hazardous material permit that we get to issue, so it's still saying that, we don't cut your head off. We just said, you basically got to come and chat with us and explain to us why
Exactly.
this may be okay. Which I think is fair enough. And then there's a corollary to this change in 220.17.3D. You say storage containers and storage trailers are prohibited from containing any hazardous material, and you'd add or regulated substance to that. That puts a belt and suspenders on that.
Yep. Consistency.
Now, are you calling that D? I mean, I don't know if there's a lettering issue. Because that storage container starts out with like A.
220.17.3, I have A, B, C,
Oh,
and D.
okay, sorry. Right.
C and D.
So after hazardous material, you'd add the word or regulated substances.
Right. But the class 6 road building requirements, it looks, I don't know if that's prior to the issuance of a building permit, the lot owner shall provide evidence to the building inspector that the waiver of liability has been recorded at RCRD. And 2, provided evidence acceptable to the building inspector that the lot and any buildings therein are insurable. Is that? I mean, is that whole everything from prior to issuance of a building permit? Is that new?
No,
Okay.
that was one of the statutory changes.
Okay.
Yes.
Right. And then the substance of these changes then seem to just be now, indicated by relocated from Article 5, right? Any other questions from the board? Or anything? How do we want to phrase that change? You want to just take a vote on, the addition of,
Well, no,
or just do it?
you just add it to, with the included change when you make the
Okay.
motion.
All right. Anything else?
No.
That's, then I'll close the hearing for Z26-3 at 7:24. All right. I move to propose the zoning amendment in Z26-3 with relevant changes added to the warrant as being recommended by the planning board.
I'll second it.
Any discussion? All in favor?
Aye.
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 Opposed? Abstained? 5-0-0. All right. All right, next on the agenda, Z26-4. I'm going to open the public hearing for Z26-4 at 7:24. Proposed Article Z26-4. Proposed Plastow zoning amendment Z26-4. Are you in favor of the adoption of amendment number 4 as proposed by the Plastow Planning Board to the Plastow zoning ordinance to amend Article 4, natural resource protection, reducing prime wetland setbacks to read as follows? I guess I'll just read the whole thing. It's not much here. So 220-18.3 boundaries and setbacks. The wetlands conservation districts include a wetland buffer area comprised of all land parcels parallel to and measured from the edge of the wetland boundary on a horizontal plane to the width defined below. So it looks like we're changing the prime wetland limited use buffer from 100 to 50, parking and structure setback from 125 to 75, wastewater system setback 125 to 75. Right. Any discussion on this? We're just basically putting this back to what it was.
What it was.
What it was
Well,
before.
It never was,
Yeah.
remember,
I mean-
it was put in as a placeholder
Right.
without having the consequential definition of prime wetlands. So if it's a placeholder, which I'm fine with, then we'll just put it to the wetlands greater than 3,000 square feet.
Right.
You know? I mean, fundamentally, I believe we should have a definition of prime wetlands in this town. Again, given the nature of what we have. And if the town wants to have a conversation on increasing those setbacks, they should be done in concert with the definition of prime wetlands. You know, we shouldn't be arguing them in a different context.
Does
It's
anyone-
just,
Does anyone want to have that conversation?
I think we're done with that conversation.
I'm good.
well, put it this way. Well, I believe we should have a definition because of the nature of the wetlands in this town. And remember, the vast majority of these wetlands are created by the brickmaking, business of the town way back, then that's a conversation we should have in concert with setbacks, so. And no, I wasn't going to raise it, but.
All right. Any discussion from the board?
Nope.
The public? All right. And again, this is just for purposes of saying it out loud. These are on the planning board website, correct? This refers, okay. So anyone
That's what
exactly.
you're on. Right.
So what we were seeing here is, what people can go see if they want to go out to the website. All right. Very good. All right. So if there's nothing, then we're going to close this public hearing for Z 26-4 at 7:26. All right. I move to post the proposed zoning amendment Z 26-4 to warrant as being recommended by the planning board. Do I have a second?
Second?
Any discussion? All right, all in favor?
Aye.
Aye, opposed, abstained, 500. All right, I'm going to open the public hearing for Z 26-5 at 7:28. The proposed blast style zoning amendment Z 25-5. Are you in favor of the adoption of the amendment number 5 as proposed by the Plastow Planning Board to the Plastow Zoning Ordinance Article 5, establishment of districts and district regulations to replace Article 5 in its entirety and replace it with the following? All right. Dan, you just want to reference what we're looking at in terms of changes or additions?
So the vast majority of these changes are stylistic in terms of that I basically just compressed all of the tables. So it took about 67 pages and condensed it down to about 15.
Yeah, it's so you've condensed it, but it's also referencing, a table that you're gonna
Yeah,
show
so
right there in the back.
that's where all the compression happened
Okay.
I used 4 pages to capture probably 20 pages of text. And then this is how we tie it back to the definitions. So if you look at, just pick any one of the tables, if you will, like if you pick the commercial and mixed-use districts. So I have the permitted uses. I have the ordinance where that use is referenced. So Article 2's definitions, but like cemeteries has its own article number. And then I just set them up the way they were set up in the tables, is permitted by right, permitted, combined, permitted with restriction, permitted by special exception, permitted by conditional use. What I did do is I thought we were light on the definition of the overlay districts. And these are material. They do affect, uses all throughout the town. So I basically terminology from the specific ordinance area, because many of them had their own ordinance areas.
Right, when you're saying overlay, just for people listening, what are you talking about specifically? You're talking about like,
So an overlay district sits on top of a base district.
yeah,
So the overlay generally adds or restricts, in some cases, the uses that can occur in that base district.
yeah. So by way of examples, like C3, right?
Right.
No.
C3.
Well, C3 is not an overlay district. That's a base district. You know, the aquifer protection district, if you will, is an overlay district. Sits on top.
Buildings to build on top.
C3 was carved out of C1 to be its own district. That's how it's defined in the ordinance.
Well,
Put it this way, if you want something to be controlling, you want it a base district.
Right.
It's on the zoning map as a base district. C3 is. And the zoning map governs, that's what,
there's definitely differences between the two. However, they both,
well, no different than resident, RC1 and C1. There are differences between them. They're different districts. So it's C3 to C1 to C2 even.
no, it's not the same.
No, they're different.
Right.
You want to talk about it looks like Schedule 220-34A. It's it's in back.
That is the list of in the commercial districts and where mixed use is. So that covers C1, C2, C3,
Yeah.
portions of the village center, and portions of the ICR. So when you were looking at funeral establishment, there was a permitted use in these districts, never defined. Private service club, same thing.
Right.
So that the vast majority of the changes in Article 2 relate to uses that were permitted but not defined. Industrial does the same thing. And then, Table 230-34A really goes through and summarizes all the dimensional requirements.
Yes.
So when you see something that says front yards, that's a definition. Okay, you know what that means. Minimum lot area, it's a definition. Maximum building area is a definition.
Right.
That wasn't the case before. I mean, again, and some of this is words have meaning. They don't all have to have a definition, but we tended to use them as defined terms, and that was the kind of
It's a lot more different.
boilerplate for this.
Yeah.
I think this becomes a little bit more readable to the average person. They can go right to a table and see it.
That's true. That's true.
All right. Any questions from the board?
Mr. Chair, if I could, the building inspector wanted me to voice his opposition to section 220-44, which is about use not permitted or specified. It talks about how the code enforcement officer would be assigned, can assign a proposed use to an existing permitted use, and so on. And he's concerned about a conflict of interest here and how that should be a function of the zoning officer or zoning official. And I know there's provision in the regulation to assign the code enforcement officer with the zoning official's duties if that person isn't present or if that person is not there. But he wanted me to just express his opposition to you.
Specifically 220-44?
Yep.
All right, so. All right, so let's, 220-44, use not permitted or specified. Any use not listed in tables 220-32-A through C is not a permitted use. For uses that are not listed in tables 220-32A through C, the code enforcement officer may assign a proposed use to the existing permitted use category within the permitted uses listed in table 220-32A through C, where the code enforcement officer issues a written determination supported by specific findings of fact that the proposed use is related to an existing permitted use and is in all material respects essentially the same as a listed use in the table 220-32A through C in terms of, but not necessarily limited to, traffic, noise, odor, other pollution, and likely impacts on town services and abutting lots. All right, where the code enforcement officer determines that a proposed use is not essentially the same as a permitted use listed in tables 220-32A through C, to assign it to an existing permitted use, the owner of the lot may appeal such decision to the zoning board of adjustment. The zoning board of adjustment shall determine how the proposed use will be permitted, if at all, including the designation of districts and whether it shall require a special exemption or conditional use permit. Annually, the planning board shall review such proposed uses and consider proposing for town meetings adoptions and amendment to the ordinance. All right. One more time, what's the,
We're just going to ask the same thing.
yeah, what's being objected to? One more time.
That those duties are assigned to the code enforcement officer instead of the zoning official.
Oh,
But
okay.
but effectively, we've gone years without having a
one.
zoning officer,
Yes, exactly.
So the code, these by default go to the code officer. How we dealt with that in the enforcement ordinance is we just kind of created an or. So to me, if I don't think this is a big deal, why don't we just say either the zoning officer or the code enforcement officer? It's kind of how we handled it in the enforcement provisions.
Right now, do we have both?
Well, we do, but I think one's retiring.
Yeah, right,
So we will have none.
right.
Right, so if you have one or the other, if one of those positions, say, isn't filled, then the other one has it.
Yeah. That's how we dealt with it in enforcement, because sometimes we weren't going to have both.
Yeah. Yeah, and that way, yeah.
We should have both, though.
So what I would say is after 220-32A through C, either the code enforcement officer or the zoning officer.
So I guess what I'm asking is, we aren't planning on having both ever again?
Well, it's,
But
if we take
sometimes you
care
have
of it
it, right,
here.
that position can be open sometimes.
Yeah,
Obviously, you want them both filled. But, sometimes circumstances happen and the position becomes open
No,
until it gets filled.
It's been that way though for a very long time.
Wouldn't code and zoning be under the same umbrella?
virtually all towns of our size, there's only one.
Yeah.
It's a code enforcement
I don't
officer.
understand why we'd have two.
Yeah,
Okay.
I don't either, but
Just
We did.
saying.
yeah.
You know,
I mean, but I think that covering this with either
Yeah.
helps.
Yeah.
And
Yeah, okay.
we do.
yep.
So I would put, where I would put it is after in the first line of that sentence, A through C, I would say either, and then the code enforcement officer or the zoning officer. And then I would use the third sentence down where where either the code enforcement officer or the zoning officer issues a written determination. And then you would have in the second sentence, the second paragraph, the same thing.
Same logic.
Yeah.
So whenever that person is not available, who is the next person in line to do it?
Building inspector. Building inspector.
Well, the building inspector typically is the code enforcement officer.
Right.
But there's in Article 20,
saying.
Article, I think it's like 22, is the enforcement processor. At the end of the day, everything rests with the town manager.
Right.
So,
At the end of the day, it does.
so there's a process where you get to it. So you're never without someone who's going to speak as to enforcement. And ultimately, it's the Board of Selectmen who enforce the ordinance.
Correct.
And they never give up that right. They can appoint someone to act in their stead, but they never surrender that right. So,
I don't understand why we have such a hierarchy of all these people when the building inspector really should be the only person involved here. It really should. Why are we paying for all these other positions? Well, I don't understand that.
If that person does the job and is always available. A lot of times people are complaining because when they start adding to their building or whatever and nobody's there. Nope, sorry, they aren't around, can't do it today or the next day or the next day. So because they're,
It really, no, it definitely is. I'm just being, just voicing my opinion. Why do we
No,
have
no.
all these people that,
yeah, I'm not saying a lot of people, I'm saying two. So one's always there, the other one can't. That's all.
All right.
all right.
But are we comfortable with inserting the either code
Yes.
enforcement or zoning officer?
Yeah,
Okay.
that's fine.
All right. Anything else with respect to this? This particular amendment?
Other than you mean
But that's
closing the public hearing?
Right, yeah, but, oh yeah, well, let's just keep it open for a minute longer.
No, I just,
Right. All right,
you might as well have read the amendments.
yeah. All right. As of, I'll close the public hearing at 7:43 for Z26-5. All right. So I move to post zoning amendment in Z26-5 with the changes specified to warrant as being recommended by the planning board. Do I have a second?
second,
All right.
I beat her to it.
Any discussion? All right. All in favor?
Aye.
Aye. Opposed? Abstained? 5-0. All right. Jeez. All right. Going to open the public hearing for Z26-6 at 9:44. Proposed Plastow amendment in Z26-6. Are you in favor of the adoption of the amendment number 6 as proposed by the Plastow Planning Board to the Plastow zoning ordinance, Articles 16 reserved for future use to replace the following? Now, Dan, this particular one, again, is, Article 16, there wasn't an Article 16, correct? And so that this is just where we're housing.
Yeah, Article 16 used to be some, it was either stormwater or one of those things, and we moved to the site plan regulations.
All right, and so what's being moved to Article 16 here?
Is some of the language from the existing non-conforming language that was in Article 3, and then a fairly significant addition.
I'll spend a little time on it then. I mean, just because, it is new and, it's probably,
Yeah.
something that came directly out of.
Spent some time
Yeah.
last time.
Yeah.
We were here, so presumably you took notes. the whole idea here was to correct what council saw are some deficiencies in our nonconforming statute. There was a fair amount of ambiguity, and we were effectively, or could be effectively, permitting things that we might not otherwise want to permit. And, just for the record, storage facility wasn't one of them, but there are other uses out there that we may not like that could have been, that could have made the same argument.
Right.
So this ordinance attempts to address that in a way that allows people to continue to use their property, which was the whole idea here, which was not to just bar something outright, and establish a process, as to how that would happen. And we did that through basically a definition, which is in 22017, 117.5, substantial expansion or alteration. I basically created a threshold for changing a use or a use within a conforming or non-conforming structure or on a lot that said if you're going to change the building coverage, the building square footage, the building area, et cetera, the lot area, you could do so up to 20% by right. No one's going to blink. And that notion came from the town of Hanover. Because there's a guy on the ZBA there named Bernard Waugh. He's an attorney, well-known attorney in the state of New Hampshire, and he is the guru on nonconforming use. So I attended a training where he had been a presenter, and I found him very interesting and certainly knowledgeable. So not like I use the town of Bow because of Steve Buckley's on the ZBA there, and he's the general counsel for NHMA. I figured these guys are working language that makes some sense. So, and the architecture here is the town of Bow's ordinance on nonconforming use and nonconforming structures. So, the definition of substantial expansion or alteration is mine. All right.
All right, so why don't we read that? Substantial expansion or alteration relating to any lawfully existing non-conforming use or structure. A substantial expansion or alteration is deemed to have occurred when any of the following exists.
Yeah, so all that does is, again, it sets defined terms here, gross floor area, building, traffic. It deals with size expansion and use expansion that could impact neighbors. I mean, just remember, the notion of non-conforming use is you want to drive all those uses to zero. Yeah. The zoning ordinance is doing that. It's deciding that, but in the meantime, you have to be mindful that people have a constitutional right to use their property.
Right.
And then it created another definition called initial proportional nonconformity, which essentially establishes the base from which you can increase your nonconformity for. What we didn't want to do is create some process that was iterative here, where someone would go to increase it 20%, then 20%, then 20%.
Right.
Pretty soon you have,
Definitely more than 50.
take 1 acre, make it 10 acres, it never stops. So this creates what the base is from which you then get to increase. And the notion here is at 20%, from over 20 to 50%, you just have to go through the special exception, which is relatively benign. There's a bunch of things there, but they're relatively benign. And then anything over 50% is just not permitted.
Right.
All right. Right, that's expansions or alterations of either a non-conforming structure or conforming structure containing a non-conforming use that result in greater than 50% increase for initial proportional non-conformity are prohibited. All right, so let's see, you have a cap on it. All right,
Abandonment, the general language, the vast majority of language is from our existing ordinance. Standard lots, it's identical to our lots. The right to continue is just the first three subjects, and then like the junkyards are from our ordinance. But I added stuff like, if the tenancy changes, it's not a change.
and just indicating, let's say the special exception, E, I guess a number of requirements. Are those again pulled from, Bo
Yes, and Hanover.
and Hanover?
And some of ours too.
All right.
So it's a combination of all. So the well is from ours. The lot frontage is from ours.
Yep.
I will tell you, the burden of proof is the statute requires. The burden of proof is on the applicant. Number 3, when it says the proposed expansion has arisen naturally through the evolution of, that's right from the governing court case on the expansion of nonconforming use. Same thing with 4. 5 is from ours, 6 is from ours.
Now, Bill, did you have any? I know this. This was new in the sense that did you have any specific questions on this one?
Oh, good.
Okay. All right. Anyone else have any
Again,
questions?
as I said, this came together quick. This wasn't on the original list, mostly because of what was going on. We looked at it and we said, okay, there's some apparent deficiencies here. Let's fix the deficiencies but in a softer, gentler way,
All right. Yeah, it should be noted that, it's, in this sense, the process kind of worked, in my opinion, right? There was something addressed with respect to a deficiency in zoning. And, so we kind of spun something up here to kind of remedy it. All right. If there's nothing else, I'll close the hearing at 7:54. And 6. I move to propose zoning amendment Z26-6 to warrant as being recommended by the Plastow Planning Board.
Second?
Right. Any discussion? All in favor?
Aye.
Aye.
Opposed? Abstain? 5-0-0. I'm going to open the public hearing for zoning article Z26-7 at 7:55. Proposed Plastow zoning amendment Z26-7. Are you in favor of the adoption of amendment number 7 as proposed by the Plastow Planning Board to the Plastow zoning ordinance to amend Article 24 noise and noise limits per House Bill 272 related to farms to read as follows? All right, this one is 220-147, exclusions and exemptions. Number 5, striking out farming equipment or farming activity. Noise from activities related to farms, agriculture, and farming is defined in RSA 21:34-A. This exemption shall not apply to agritourism as defined in RSA 21:34-A, Roman numeral 2B5. All right. Any discussion on it? This is in conformity with a House bill.
If I was writing this, I would have permitted agritourism to be. But,
That's right.
but
I was going to say, if you were writing it,
really,
then,
they didn't let me write this one.
Maybe next year.
so I think this one's pretty straightforward. I mean, this is being driven legislatively. All right. So
Yeah.
again, House Bill 272. So, it's, any more discussion on that? Right. Dan Kane should not be writing any of these House bills.
Anything
maybe.
related to agritourism.
Okay. All right. So if there's nothing, I'll close the public hearing at 7:57. I move the proposed zoning amendment Z26-7 to warrant as being recommended by the Plastow Planning Board.
Second it?
All right. Discussion. All in favor?
Aye.
Aye. Opposed? Abstain? 500. All right.
It's very end.
Stack's getting smaller.
Yeah.
Oh,
I'm going to open the public hearing for Z26-8 at 7:57. All right. Proposed Plastow zoning amendment Z26-8. Are you in favor of the adoption of the amendment number 8 as proposed by Plastow Planning Board to the Plastow zoning ordinance Article 8 accessory dwelling units to read as follows? All right. Is this, again,
This was a result of one of the House bills. I think it's 557 or 457, one of them. But, the state has basically looked at what some towns were doing with ADAs and thought they were overly restrictive. But Plastow wasn't one of them. We allowed for attached and detached. We have a fairly generous 1,000 square foot, kind of permission, size. Where we started to stray into the area the state didn't want us in terms of the existing ordinance was establishing design standards on the ADU that weren't established for single family dwellings. We were playing around with the entrances. We had some restrictions on utility hookups. Those have all been removed. And council on this one, we had a provision in here where essentially you could, if an ADU was sold, if the single family residence was sold and the ADU along with it, then the new occupant of the ADU would require an occupancy permit. Well, we don't require that for single family homes, so we can't require them for these.
Okay.
So
Are these ADUs permitted for in-home business use? Do we know?
well, again, I think it relates to when you get into that article in the ordinance, the home occupancy,
Right.
the home. They would be if they met the conditions of that.
Okay.
So if you had a home office in the ADU, you could,
It's, it appears that it does. I'm
Yeah.
just throwing it out there
Yeah,
for
no,
public.
no, but a home business requires a conditional use permit from the planning board.
Correct.
So a home office doesn't. You can use that by right. But the definition of a home office is no one would know you're there. you know?
Right, right. Well, I'm not talking about putting a body shop in there.
Yeah, right.
Just-
Yeah, no. And again, the home office, the home occupancy kind of things are fairly narrow as to what kind of professions and what kind of can go in there,
Correct,
you know?
correct.
So,
Yeah.
I mean, it's kind of the discussion that we had on the back end regarding the church, you know?
Yep, yep.
You know, that's not a home occupancy because it's not a home business,
No.
you know?
Right.
It does say it's listed as 1,000 square foot maximum.
The statute has them, you know, they can't be less than 750 square feet,
Right.
you know? I suspect as the state starts playing around with this more, you'll see something start to
Change,
increase, you know?
Yeah, 1,000 square feet seems kind of small, but
As far as ADUs go, it's probably on the larger size if you look throughout the
1,000
state.
square feet's a decent size.
I've built a few of these
Yeah.
in my, and I think the max back in the day was like 600 or 700 square feet.
Yeah, no,
Yeah,
they're just
right.
tight, you know? Yeah.
That is tight. That is tight. 1,000 is not too bad.
I mean, to me, if you were in the 12 to 1,500 range, once you start getting a 1,500, you know,
It's another house.
yeah, bingo,
It's another house.
bingo, bingo. And then that changes the accessory nature of it.
Absolutely
you
does.
know?
Absolutely does.
Yeah, when they first went in there, more in-laws, things like that, right?
But if you were looking at these like to play around with, to me, if you got closer to 1,200, you know, that's probably the upper limit of these
I
things.
think my first house was only 1,200 square feet.
Yeah, mine was. Yeah, mine was.
It was like 1,200, 1,300.
Yeah.
Is B, 220-57, B, accessory dwelling units are permitted to be converted from structures existing prior to July 1, 2025, including but not necessarily limited to detached garages, regardless of whether such structures violate current dimensional requirements for setbacks and/or lot coverage. Is that contemplated in the legislation, or is that
It's word for word. from
word
the
for word? All
legislation.
right. Okay.
I mean, the zoning board had well, it's only variance, you know, in the last few months came up as a result of something like this. Never should have been in front of the zoning board, you know, because it was after July 1st, 2025, they were taking a garage and just not expanding the footprint and the dimensional, you know, kind of nonconformity was just how close it was to the lot line. So under that scenario, this thing goes in as a matter of right. That's what they're making. Because that's another thing that the state was concerned about, is that a lot of these kind of pre-existing, you know, structures that, you know, in many cases might have even predated some of the zoning ordinances
Right.
were now precluded from going through and being converted to ADUs. You know?
No, I'm just curious that let's, you know, something like this where it's being driven by the state, for some reason it got shot down in Plastow.
It's irrelevant.
Yeah, this is, you know, so this is really kind of,
Yeah.
It doesn't
just-
make a difference.
Nope.
I mean, they can make a statement, but no one's listening.
You made a statement, doesn't mean anything.
Yeah.
You can run it up the flagpole, no one's gonna salute.
Well, again, regardless of what this is
Why is it
in
around?
effect right now.
Right.
Exactly. Exactly.
All right. So any questions more on this? If not,
Nope.
we'll close the public hearing at 8:05 for Z26H.
I second it.
All right. I move to post the proposed zoning amendment Z26.8 to the warrant as being recommended by the planning board. Karen, okay, all right. All in favor?
Aye.
Aye, opposed, abstained, 500. All right. I'm going to open the public hearing for Z26-9 at 8:05. Proposed Plastow zoning amendment Z26-9. Are you in favor of the adoption of the amendment number 9 as proposed by the Plastow Planning Board to the Plastow zoning ordinance to amend Article 20, Zoning Board of Adjustment, add the section 220-137.8 Appeals per House Bill 296 to read as follows? I guess we can read it. See, 220-137.8 Appeals. Any matter, what's that?
I'm going to read it.
No, okay. Well, it's up on the screen, all right.
Right. Everybody can hear it.
All right, again, this is being driven by House Bill, correct?
Yes, and what's being driven is the 30 days, okay? Is what's in there now is in the statute, the previous statute was, there was allowed the ZBA to determine what that period was. Now they just limit it. So this is statutory language that surrounds the 30 days, you know?
Okay.
And we didn't, in the existing ordinance, we didn't necessarily have an appeals provision, you know? So this just puts it in there.
Oh, that's right. Yeah.
All right, so this portion here where it talks about zoning board of adjustment may hear appeals of the planning board decisions.
Yeah, that's just statutory.
Okay.
We know that works because we just had one.
All right. Any questions from the board? The public? All right. Not. And I'll close the public hearing for Z26-9 at 8:07. All right. I move to post the proposed zoning amendment Z26-9 to warrant as being recommended by the planning board.
Second it?
Any discussion? All right. All in favor? Aye. Opposed? Abstain? All right. Z26-10. Oops, I'm going to open the public hearing for Z26-10 at 8:08. The proposed Plastow zoning amendment Z26-10. Are you in favor of the adoption of the amendment number 10 as proposed by the Plastow Planning Board to the Plastow zoning ordinance to amend Article 10 home operation to read as follows? 220-67 conditions applicable to all homes. There shall only be one home operation per lot except where the second use is a home office.
What does that mean exactly? It's a little-
It is essentially, so under the current ordinance, you know, you have home operation, home office, home operation, home business, and then the child daycare.
Separate.
You know?
Okay.
So those are the four things that fall under the definition. So home office, you can do by right.
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 In the wording, I know I wrote this, the wording here I thought was too narrow and that you would have to argue the per right. I just think the intent was not to bother people about their home office.
Yeah. I agree.
Yeah.
I agree. I just wasn't sure what that was.
Yeah,
going.
that's why. It was
Especially this
just,
day and age with everyone working from home.
yeah.
Yeah, that's what I
Leave the
mean.
home office alone, right?
I personally would like to say, except where the second use is a home office or homestead food operation.
Yeah, I mean,
Yeah, that's,
I don't,
I don't see anything wrong with that.
the problem is now that's defined in home occupation. Now you've eliminated, you're opening up home occupations, you know? You got the zoning ordinance?
That one.
I think I do.
You should be able to pull it up on that laptop.
You think so?
What are you looking for?
I'm looking for Article 8, the home.
Mine's up to date here.
The home operation ordinance.
Article 10.
Article 10, I'm sorry. Yeah, if you go to the zoning ordinance,
Bottom
Nolan?
tab on the board.
Hold on. Look at cheaters now.
down the bottom.
Yep.
There you go.
Know the feeling.
No,
No, I gotta take them off to read.
I can't see shit with them.
No, when I leave, I gotta take them off.
all right,
Is it?
down to Article 10, yeah.
Page 118.
Oh, I can't.
Is it page 118?
Yeah.
There's no
Page 127.
some help with that.
Is it 127?
What, 120?
Hmm.
The printing on it? I'm like, I can't read this freaking 3-year-old. I got
You're in the
this.
homework.
I got a magnifying glass. I'm
All
like,
So go to,
I said, you figure this thing out. and do it.
What page was it again?
Well, it's gonna be 127. It's
Yeah,
just,
that's
stay there. Yep. So let me go to definitions.
Shut up.
So homestead food operations fall within a home occupation. So when you look at, if you start carving them into multiple uses, go up to 2066, I think, which is, yeah, right in here. So you can see occupations is a fairly broad, definition of professions. And what the ordinance does is amend that definition and add homestead food operations as a home occupation. So if we're going to allow multiple uses, why would we just include a home, a homestead food operation? Why wouldn't we include other other occupations? And again, personally, as you know, I read the ordinance. I'm not opposed to it, but I'm just saying is now we start looking at it in the context of which this ordinance was developed, which is now, if you're going to allow homestead food, you can allow two jewelers, two things. And the idea was not to have, a bunch of multiple businesses sitting in the home.
right.
Home office, you wouldn't even know they're there. They're
Right.
running, they're answering.
So this is basically like somebody selling like food to the public from
Right,
their
yeah,
house.
Yeah.
Like
So
that.
using, and again, I can see the distinction because you're using your kitchen, you're not out in the garage.
Correct.
Becoming Hewlett Packard 2, so I get there is a distinction.
Yeah, that's a tough one because I could see that all day long being two in the same house all day long.
Yep.
All day long. I'm not opposed to it personally, but I don't, doesn't appear that the statutes allow for it.
Well, the way it's set up now, it doesn't.
Right. Right.
Exactly.
Yeah.
Doesn't mean we can't change it for specifically that. It's kind of a unique thing. It's not like you're operating
Yeah, no, I can.
two different like commercial businesses. You've got a homemaker selling pies and somebody else maybe doing online sales, who knows, whatever. And I don't see any issue in that at all. Not at all. Not especially in this day and age.
How about this? This is fairly innocuous. How about if we table this? Let me talk to council a little bit
Okay.
and see what they say.
I would like to further this. I have no interest in this personally at all.
Yeah.
But I think that it's something that should be looked at
Yep.
because why not? Why not? There are tons of people that sell products they make at home.
And they're
that
going to anyway.
Years ago, they couldn't even do that without a commercial license. And they can now, which is great.
It's been, the state has been able, it's been throughout the state for quite some time.
Yeah, but I'm saying
Just
here-
Plastown. It was just Plastown that was prohibiting it.
Okay.
My right. and the
Like I
rest-
said, I mean, I own a restaurant, but I don't sell anything at my house. But for the person, the lay person that wants to produce something and sell it, I'm all for it, all for it. But if all of a sudden the husband has another in-home business,
Right.
Well, it depends what the business.
well,
is,
yeah, of
right?
course, of course.
I mean, if it's just, over the computer and
If
nothing's
it's
coming
just
in
a
and
home
out,
business.
Well,
then that's a home office.
Yeah, again, in all honesty, my wife is a psychotherapist, and she has 2 offices in Plastow, 1 in Florida, 6 in North Andover, but she works out of the house also. So if I wanted to make apple pies and sell them, I can't. I'm not going to, but I'm just saying,
I heard you're not that good of a baker.
I'm not. But the thing is, you should have that ability. This is live free or die state. And we need to look at that a
So
little
this
more
is
in
something you want to
depth.
bounce off of.
I
I
want to,
can do
council,
that.
and
Yeah.
let me play with it a little.
Yeah, because the key is you got to make sure you don't open it up to something else.
Oh.
And that's the thing.
That's
And that's the
probably-
fine line.
Other
But we're talking about food here.
No,
We're not talking about
I get
anything
that,
else.
but how to do it, right?
Right.
I mean, it's not like you don't want a car repair shop,
No, that's not what we're talking about
No,
here.
I understand that, but it's a way to, and I think, speak to council, see if they have a way around it.
Yes.
Well, the challenge is how we define the terms. you
Correct.
know,
It's all in definition.
Yeah.
It's all in definition. It's all in definition.
So for purposes procedurally here, do we want to continue this
Yeah.
Yes.
hearing to
Yes.
This one.
Yeah.
Yes, absolutely.
a particular date certain, or
Our next meeting.
Next meeting, I think.
you're going to be here next
I
meeting?
am not going to be here.
All right.
That's right.
Okay. Well, why don't we then continue it to next meeting, and then you want to provide input then?
I can get you everything. I don't need to be here.
Right, exactly. All right, so we'll continue the public hearing for Z2610 to, today's the 3rd, to what, is it 17th?
Yeah.
December 17th. All right,
Continued.
You can see as the calendar starts to get skinny.
Yeah, it does.
all right,
So we're continuing it to the 17th?
all right, so,
Thank you for manning that in a
Yeah, it's one of my main skills.
highly professional manner.
I don't know how to do it.
Yeah, the food thing is kind
all
of
Well,
right.
you put the
I would
previous
never know how to
operator
do
to
it.
shame.
gonna be a big thing, but
So just for purposes of wrapping things up here, do we have any old business, anything that anyone wants to, that we should be talking about? Shay, do you have anything for us? No? All right.
We're busy for the
Any
next
new
meeting.
business?
I do have something for new business.
Okay.
The Energy Committee just met actually just before this, and they're interested in looking at updating the solar ordinance in the zoning, and potentially working with the planning board this next year on updates.
Yeah, that was, we kind of started tweaking around with that in the committee. That's a good one.
All right.
Yep.
Something's right in my way.
That's excellent. Anything else?
I have one question. CIP, are we going to get together in
gonna-
conversation before warrants are done?
I'm gonna, before them, yes, we'll get there. Maybe just in
Because
time.
I think January is like the first week of January.
So I've got a memorandum that I will share with Shay tomorrow,
Okay.
and we'll send it out and try to get together next week. I will tell you, we only got a couple of things back,
And
so.
that's okay, for me, I'm just speaking for me, something's better than nothing, and getting it in the plan to just have that conversation of what we're going to bring forward. Is enough.
Well, and I don't necessarily disagree. My issue though is, you guys, we solicited your you solicited your requests months ago. Get them in. We're not making a judgment on them unless we look at this in total, because we've got a fixed amount of resources here. And, so I didn't want to necessarily deprive anyone of their voice.
Right.
Just,
We're going to I'm going to solicit next week. I mean, I have some thoughts, but we're going to solicit getting together next week. And I think we can make short work of this.
now, have you received anything in the way of at least even just confirmation that no changes to what's on the CIP
We got
spreadsheet?
like 5. I got the library, I got the police, I got, the big ones. Highway said that they were dealing with the Board of Selectmen directly. And I got building, which is, that request is got some heft to it. But that's what I have.
Okay. Anything else?
Only other thing is, I happen to notice, I happen to pull into Methuen Construction. There's still no sign saying no right turn.
Again, that's something from the,
I
that's,
pulled in it
Yeah.
just because, and I'm like, there's no sign.
That's
There's no nothing.
the thing is so Methuen Construction sits here,
Yep,
town land sits there.
yeah.
Yeah.
So the town actually, the Methuen Construction is permitted to use the town land as
Yes.
exit entrance,
Yes.
subject to an easement. That easement includes the sign that prohibits the right-hand
Could
turn.
they just
No
move the
sign.
darn sign?
is that something
So
that
the
can be
question
brought up
is
at the Board
whether
of
it's the
Selectmen?
town's responsibility or Methuen Construction's.
What?
But their easement requires a sign.
This has been going on for a few months now. We've talked about this. And there's no sign, and those trucks come right out of there.
They do.
And mayor's trucks are still doing,
Oh, no.
they're all still doing it.
Yeah, everybody's doing that.
So
They're driving
here's
right
what-
by your house and my house.
Here's what I've done. So the last couple of days, I've sat in my driveway starting at about 4:30 in the morning
Oh, my God.
and just taking pictures of the
Yep.
trucks coming by.
Yep. Yep.
Sit there with a couple of iced teas and a blueberry muffin. So it's ridiculous.
It is.
And everyone's,
And they are coming both ways, too.
yes.
They're
Right.
coming both
I was
ways.
just going to say, this one is just coming right through the school time, every damn time at 3:00 in the afternoon. How many I've seen?
Yep.
Go right through there.
I mean,
Yep.
Tormeo's
And we
coming
don't even
down.
have a
His
guard
guys
anymore.
are using it
Yep.
as as a shortcut. So,
They all are.
uh,
I don't know what we do about it. I
Well-
mean,
nothing stops us from pointing it out to the people who are doing it. And,
but if the sign's out on the
Yeah.
property,
Correct.
then we have no
There-
enforcement.
You have
Correct.
no enforcement.
now
That- you gotta
I
get
plan to go
enforcement.
down to Mayor and see if their sign was on the property. I will tell you that Milton Cat put their sign on the property.
Did they?
Yes.
Yeah, it was up.
Yeah,
near-
I specifically pulled into Methuen the other day, and I'm like, yeah, there's no sign here. And then I could easily pull into Mayor also.
Yeah.
It's not a big deal. We both live on the same street.
Right. No,
It's not a big deal.
and here's the thing is, we use the enforcement mechanism. We had someone go talk to them politely.
Yep, in the beginning.
I think things need to be, the next escalation
Yep.
needs to go
I
on.
agree.
I agree.
That needs to happen. Those trucks come flying down that street.
No.
Flying.
Oh, they are already.
I mean, with
Someone's going to get hurt.
traffic calming is obviously thematic. If we can at least at a minimum deliver on something like that we have control over, which is if there's a sign that needs to be on an easement and it requires, let's say, Board of Selectmen to say, make it so, that'd be much appreciated. And
Why can't we make them do it on their side?
I'm taking Methuen Construction because it has to do with the easement, so that needs to come from the town.
Yep.
It has to.
Yeah, and then Milton Cat, if they've done what they're supposed to do, thank you very much. And and if they have a sign, very much appreciated. If they don't, then,
And from what I heard the other day, there's actually more than one company in Mayor's
yeah,
property.
well, if they don't, then I guess, again, that's, Shay, that's something, again, I guess the planning board is interested to know if Mayor has the sign that they were asked to put up. So,
I'll check it out myself.
What do we go about now to the selectmen to work on the sign?
we have two selectmen here that can.
Okay, nice.
All right. Anyone have anything else?
No.
Just one last thing then. In terms of traffic, I watched the Board of Selectmen meeting the other day. Is there a meeting? Yeah, I was there. I wasn't the guy commenting, no.
I watched it. You might not be captured.
Is there a meeting of some kind with the state or anyone with respect to calming that's looking for
I
input?
know they were trying to set it up. I'm not on that committee.
Oh,
Jay's name was mentioned. Is he somehow the point of contact? Or?
He probably would be.
Yeah.
yeah, they're probably not gonna get it before Christmas,
Because I'm not on that one.
Yeah.
I gave my input what I thought.
Okay.
I guess.
I guess I'd be.
Agree with that or not, I was just trying to think of what I thought we could get done
Yeah.
quickly. Because if you start going down the road, say this section, that section, next thing you know, we'll be 10 more years.
Well, it sounds like the signs. I heard there's a lot of discussion about the signs. And-
Personally, to me, it's stop signs.
Yeah, it's easy.
Well, what I had suggested, in my opinion, was, because this one phase goes from the library to the railroad tracks.
Yes,
What I'd like to see is how they had mentioned that median right at the library, keep that median, because that kind of chokes it there a little bit.
yeah. a little
Then
bit.
in my opinion, I'd like to see a stop sign on Pollard Road.
Oh,
Freeway.
yes.
Put one there, and then one right out here where Elm Street has another stop sign. Three-way.
Well, East and West Pine would be,
Well, we're only going from the library.
oh,
Yeah.
okay.
Yeah, the
But it's a
library.
different project. Well, what I'd like to see, what my opinion too, is obviously at that meeting that night, that's another group that's handling that. He said next year, they anticipate putting the two stop signs on Main Street at the Pines, East and West
There
Pine.
you go.
So 2026?
Well, the thing is, with the stop signs, you just gotta stop the runway.
Right, and that's
Right,
what
well, that's it.
trucks don't
That's
wanna
it.
stop and go. And then the other thing is, they were saying the three-way up at North Ave. But what I'd like to do is get some input from the residents on Chandler. I'd love to see that become a no left turn.
Oh,
Yes,
oh,
yes, coming.
That's
out of,
horrible.
no,
So I think if you could make that
No left
possibly a
turn.
no left turn.
I agree.
Yeah,
You know how
that
they can do
intersection is
that?
horrible.
You can use Garden Street. Garden
Yes,
Street.
yes,
So
Garden
that way,
Street
you
to
come in
Pine.
that way, you can go out that way.
But I'm thinking like
is
from,
it-
from Main Street, no left turn onto Chandler.
No, I know. Oh, on the channel,
Oh.
yes.
Well,
That's right.
That's
just,
what
just,
stacks
But the
everything.
same
Oh,
way.
it's unbelievable.
So
Right.
that would be my quick thought, but I'd want some input from the residents on Chandler, because it's gonna affect them more than anyone else.
And that's-
well, here's a question. Here's a question about Chandler, because it was brought up at the one of the meetings. And I think it was Ryan Lebrecht that suggested it. He said, why wouldn't you just block off the entrance? Now, I mean, if you're talking to residents there, they might be
Well,
amenable to that,
I think
or they could
that
say
the one
no.
problem you could have if you blocked off either at 125 or at Main Street, you got emergency vehicles. So that's what you have to think
Okay.
about.
Yeah.
And there's a complex down there too, right? Emergency
Yes.
vehicles go there.
Well, no, it's the only, aged housing in town.
Yes.
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 Right.
So that's why I
exactly.
think, because you got emergency
Yes.
vehicles, that's what makes it
Exactly.
tough. But I think, and I was just thinking, quickly, obviously get everyone's input, but I think if you went Chandler, no left-hand turn, that would stop that stacking up.
Yeah,
Exactly.
That's a brutal intersection.
Yeah.
I actually know the owner of the property that is on the corner of it, right there, at the red house.
You're just going right,
It's brutal.
left. That's it, not.
He actually put
left.
boulders at one point in front of his house, and they kept hitting him and sending the boulders flying. I'm like, oh my God.
and then he got bigger ones.
You know what? The other thing is though, Richard, you know what? I think they should still do, they did say it at the meeting, but you could always be on their list type thing. I still do not want to rule out that we can't do a roundabout sooner or later. But they said if you keep your name on there, it doesn't mean we're going to be seeing it in the next 5 years. But if anything came up, that it was suggested they could help, I don't want to rule that out. And they said,
Roundabout where? In North
right
Ave?
here, no, and this one right, we
Oh,
used to have We used to have a tree that was right there in the middle, and everybody went to the right of it to go up. We had almost one like it
The
already.
thing is, we gotta
Years.
remember that the dollar amount that they have allocated is $850,000.
See, that's what I'm
And
saying.
see, that's what you get, but with that 850, you'd have to be able to do everything
Not far.
else. But that 850, by the time they do that project, is probably only be worth about 500.
I guess
Oh, the engineering.
I had raised the question previously in regards to what the cost of the maintenance would be if the town took over North Ave and Main Street.
I know, that's the other one. Right.
Was, I mean, I don't know if that has been addressed or
It
even
was.
kind of talked about, because
Time.
it seems like waiting for the state, doing all this stuff, if we
We
took
could make the
control
rules.
as a town, we could,
Yep,
then we have control over those roads, and then we could do pretty much as we please
yes, yep.
to, what we want to,
You could
slow down traffic, whether it's no through
eliminate
trucking,
trucks.
no,
Anything.
yeah,
Again.
stop signs. We don't need to wait for approval from the state. Like I said, I don't know offhand. It just seems that for a small strip of road, it might actually
No,
be
we've been
worth
through
the
it
control. I mean, I've heard the selectmen talk about having local control over and over again. So I would urge
I'd
them
like
to at
to
least
see that.
investigate having local control over that street.
Yep, I would like to see that. I think we could try again.
What is, I mean, just curious before, not to belabor the point, but what would the process be to ask about that? I mean, if the individuals that were there at,
I'd be glad to get rid of it.
I'm sure the
Guaranteed.
state probably would be.
yeah,
I mean, obviously, there's a lot of discussion we have to go around there.
right.
Oh, yeah, we gotta go
Because
through a
now
lot.
you gotta maintain those roads when something happens, if the roads have to.
It's not just such as plowing, it's maintenance.
It's on the town.
And then we have to think about the cutouts and who has to replace those if once, what's that maintenance looking? Who's gonna be responsible for mowing it or shoveling, whatever.
Or
else is there.
repaving.
And repaving.
Yeah, there'd be the repaving.
Repaving's a big one.
But we're already doing a lot of the
We are,
streets.
for the plowing, correct.
Right, for the plowing, we're already doing
Like
that, so.
the state does we're doing the majority of the winter
Right.
work, right?
Yes,
Does the state subsidize that?
yeah.
They give us back a little something.
Yeah.
Okay.
Well, something for the
I think that is something I want
All
to
right.
bring it back up again.
Anything, I don't care what it is, anything's worth a discussion.
Of course.
Exactly,
Right.
What- Not even, doesn't have to be that, anything's worth a discussion.
right.
Agreed.
All right.
Yep.
Anyone else, anything else? If not, we'll close the meeting at 8:34. I think.
Thank you.
Thank you.
Thank you.